Right, everyone's here. Good afternoon, good evening, everybody, and welcome to this criminal law causation seminar. This is an area which is very difficult in theory, but it's also leading to a lot of appeals. And so what we want to do in this event is hear different perspectives on the kind of causal issues which seem to be coming up a lot in criminal law, with the hope that we can maybe see some new avenues for solving any of these difficulties, or at least thinking differently about them. I'm Dr. Findlay Stark, I should say. I'm an associate professor at the Faculty of Law at the University of Cambridge, and I'm also a deputy director of the Cambridge Centre for Criminal Justice, which is running this event. We're going to have three speakers this afternoon/evening. We're going to start with Dr. Jonathan Rogers, who is an assistant professor at the University of Cambridge. He's also a deputy director of the Cambridge Centre for Criminal Justice and also director of the Criminal Law Reform Now network. He has a lot of hats. After Jonathan, who's going to give us the perspective of a criminal law academic on causation, we're going to hear from Professor Jane Stapleton, who is presently Master of Christ's College in Cambridge and one of the foremost experts on causation in tort law. So she's going to give us an interesting perspective, hopefully interesting for her, I should say, on the kind of issues that we encounter in criminal law. And finally, we're going to have Vicky Ailes, who's a barrister from 6KBW College Hill and was the junior in the recent case of Field, which raised particularly interesting causal issues in the context of homicide. Each participant is going to speak for about 15 minutes. I will be more or less aggressive depending on how interesting what you're saying is at the time. And I will then open the discussion up to the audience, and I'll explain then how we're going to do questions and answers, because it's probably going to be easier to explain it then than now. So without further ado, Jonathan, would you like to start us off?
Okay, well, as one deputy director of the Cambridge Centre for Criminal Justice to another, thank you very much for that introduction. And thank you for organising this event, Findlay. You probably made a mistake in inviting me, but I'm very glad you did. Now, what I'm going to do today is talk about two particular aspects of causation and leave the other main aspect to the other speakers. The other speakers will include in their talks the cases on novice actors, but I'm not going to be doing novice actors. I'm going to say just a few words about factual causation and then the proximity test. So I have really one broad message in respect of each of those tests. About factual causation, I'm going to be saying that much depends in theory as well as in practice on whether the conduct of the accused, which is supposed to have caused the result, was an act or an omission. Some care may be needed to distinguish whether the conduct is an act or an omission in order to ask the right question for the purposes of factual causation. Then I'm going to talk about the proximity test, and my main message there will be that we should not equate it with a foreseeability test. Factual causation. So what I mean by this is the sine qua non test, as it's sometimes referred, that is the finding that had the accused not done as he did, or had he acted as he was supposed to have done, then the result in question would not have occurred. And as practitioners will know, matters of chance can play a huge role in deciding whether the conduct of the accused actually did make a difference to the result or not. One reason why fraud cases, after the Fraud Act of 2006, no longer have a causal element, as they used to be, is precisely that some victims of fraud in the old days turned out to be influenced to hand over their money to a fraudster, not on account of the fraudster's false statements, as the law required, but rather because of how well dressed and how well spoken he seemed to be. So since the fraudster would have gotten his money anyway, even if he hadn't actually made his false representations, he couldn't be said to have committed the offence of causing loss by deception. factual causation couldn't be proved, and that's why they reformed the law, or at least one of the reasons. Now, where factual causation does need to be shown, it is going to be easier to prove it when the conduct is taking the form of an act rather than an omission. Where the defendant does an act, let's say he frightens somebody, then the question whether he thereby causes a heart attack is purely factual. You might need expert evidence, but it is a factual inquiry, a kind of scientific inquiry. We try to work out what did happen as a result of his frightening the victim. We sort of reconstruct the chains, as it were, and see whether they link together. But where the defendant doesn't actually do anything, where he simply omits to act, then factual causation becomes a hypothetical inquiry. So we know from the gross negligence manslaughter case of Broughton in 2020 that the prosecution must prove beyond doubt that the accused would have succeeded in saving the victim if he had properly discharged his duty to do so. And this counterfactual question can be very difficult to establish to anyone's satisfaction. Perhaps even if the defendant had called an ambulance for the victim as he was supposed to have done, maybe he wouldn't have arrived in time, maybe he'd be caught in traffic, maybe the relevant staff on the ambulance would have had a bad day, or maybe they weren't available, maybe the machines at the hospital weren't available, and so on and so on. That's why it matters, but this distinction between acts and omissions, as you'll likely know, can be very difficult to draw. If we wanted to take an unduly technical approach to it, we might think that people often combine acts with omissions. For example, preparing food for sale, but without warning the customer that there are nuts inside the food. Which is it, act or omission? Glanville Williams once suggested that where an act is done whilst neglecting to take some safety measure attached to it, then the conduct overall should be regarded as an act causing the result rather than an omission failing to prevent the result. This can matter, and a good case which illustrates why it matters is a case of the Crown against Kudus in 2019. In this case, exactly that sequence occurred. Food was prepared and sold and consumed by the customer, but the provider of the meal had not given any warning about the traces of nuts. We'll see in this case that it really matters whether the conduct is act or omission. If the conduct is simply overall an act of providing the food, then we have no problems in proving factual causation to the customer's death. Clearly, if the owner of the restaurant hadn't given the food, the customer wouldn't have eaten it and wouldn't have died. That's easy. But if we look at it from the other angle and say that the real negligence here was failing to warn the customer of the traces of nuts, and if we therefore think that maybe this is a case of an omission which causes the death of the customer, it becomes harder because it must now be a hypothetical inquiry and the question changes. The question is now, if the victim stroke customer had been warned of the presence of nuts, would she still have eaten the meal and died? And in Kudus, this could have caused real problems because there was some evidence from which one might properly infer that the customer was a fairly easygoing person in the company of friends, didn't like making a fuss of her allergy in front of her friends, and she might well simply have just gone down to it and eaten the meal and taken the risk. And if we can't exclude that possibility, then factual causation would not be proven. So it matters whether we label these things as acts or omissions. Kudus illustrates the problem very well. He didn't actually decide the point. They simply seem to assume that it was commission by act and that therefore liability could be shown. And I happen to think that's right. But the point wasn't argued, and it may need to be properly argued in some future case. Okay, that's enough on factual causation. I'm going to talk now about the proximity test. The proximity test arises when factual causation is proven, and it seeks to limit the number of possible events which can cause a result. The idea is that it limits it to events which seem sufficiently proximate, which seem to make substantial differences. And this can be difficult where after the defendant's act, a series of other acts intervene to get to the final link in the causal chain. You may then wonder how important the defendant's contribution was at the beginning of the chain. A simple example, suppose I invite an adult friend over to dinner, but he or she happens to die in a road accident on the way over here. What I've done, the invitation, factually causes death because that person wouldn't have died otherwise, but clearly it is not a legal cause of death. The proximity test would eliminate the mere invitation to dinner. The trouble is, though, that it's very difficult to give a simple generic formula for the proximity test. We do know that we want to exclude such early random contributions as the one I just mentioned. Maybe that's simply, or we should say that proximity test is not passed where between the defendant's act and the result, there are a number of random unconnected sequences. But the courts haven't actually put it like that. They prefer to come up with specific formulae which do apply that approach, but they apply it to particular typical recurrent situations rather than offering a broad generic formula. Examples of the formulae they produced which relate to particular recurrent scenarios, well, perhaps the best one known is that relating to somebody who attacks and wounds somebody who then dies from negligent medical treatment. Does the person who wounded the victim still bear liability for death which may have been caused by negligence at the hospital? The Court of Appeal has long said, yes, the person remains causally responsible if the victim died from the wound or from the attempts to treat the wound or from complications arising from treating the wound, but is not causally liable if a patient died from treatment which had nothing to do with treating the wounds that he had caused. Another rule of thumb relates to people who may chase aggressively others, and those others run away and come to some disaster by accident in the process of their flight. The rule here is that the person who chases the victim can be said to have caused the later injuries unless the victim did something unaccountably daft, even allowing for the pressurized circumstances during the flight. In both of these typical recurrent situations, we see the same approach. We're looking in retrospect at the various links in the causal chain, and we're seeing whether we simply understand how one event leaded to another. But if the doctor or the fleeing victim acts in a way which we simply don't understand, then we take the view that a certain randomness has crept into the chain and the defendant is no longer causally responsible for the final result. What's important here is that the exercise of making sense of this causal chain is retrospective. We take the causal sequence as it turned out to be, with the benefit of hindsight. We don't ask whether, after the defendant's original contribution, the later events were foreseeable or not. Now, some do actually like the foreseeability test, and they may well say that thinking in terms of whether later intervening events were foreseeable leads to much the same results as looking at them with the benefit of hindsight and seeing whether they logically link with each other. Often they do come to the same, but not always. And to illustrate the difference again, I want to give you the facts of a recent case involving causing death by dangerous driving, where I think it really matters whether we're looking at the causal chain in retrospect or from the perspective of foreseeability. So this causing death by driving case is a case of A in 2020. A had parked her car on the hard shoulder of a motorway in the twilight hours, rather dark therefore, and she hadn't left any lights on, so she could be crashed into. And she remained in the stationary car with her friends. A lorry driver who was probably asleep, we don't know, but he was probably asleep, veered over the motorway and happened to collide with A's stationary car. And in the collision, two were injured and one of the occupants of A's car was killed. Now, the lorry driver, he's simple, he pled guilty to causing death by dangerous driving and to causing serious injury by dangerous driving. But we're more concerned with A, who had parked her car there in the first place, where she shouldn't have done. Let's assume that A is dangerously driving when she's parked her car, because she can be regarded as still driving in those circumstances, and clearly what she did was dangerous. But is there still a causal link between that dangerous driving and the injuries and deaths? The Court of Appeal thought that a jury could properly find so, and they applied a previous case called Girdler, which put the test in terms of foreseeability. In the A case, they said the question for the jury should be whether it was reasonably foreseeable that another vehicle might leave the carriageway and collide with the respondent's parked unlit car. And if you put it like that, perhaps it is foreseeable. And it would be foreseeable whether or not the other driver fell asleep. But let's suppose that instead of looking at it from the point of view of whether it's foreseeable, we'd look at everything in retrospect and try to find links between the chains. That is, if we look at what did happen rather than what we might have expected or would have foreseen could happen. As things actually turned out, if the driver was asleep, I don't think we would any longer find a causal chain, because it was purely random that this driver who was asleep happened to crash into A's car. He could have crashed into anything. It was pure random, unconnected chance that he collided with A's car rather than with anything else. And if we take it from that point of view, the causal chain should be broken. I mean, A might as well have been driving safely at the time, or she might have been parked there with the lights on, and the same accident would still have happened. Since it was thought in A that the driver probably was asleep, I would suggest that the case against A should not have been put to the jury. In fact, the A case gets even worse. The fact that the driver was thought to be asleep even counted against A, because its relevance was thought to be that the driver therefore did not commit a novus actus, which would also have relieved her of causal responsibility. I actually agree that he wasn't a novus actus, but as it happens, there's no proximity between how A parked and how the accident happened. So it matters whether we put it in terms of foreseeability or coherently linked causal chains. I think we may have slipped into talking about foreseeability over the years without really noticing it. But it wasn't always like this. In the House of Lords in 1998, a case called Empress Car Company against National Rivers Authority, another case of intervening causes, but this time in the field of environmental pollution, Lord Hoffman specifically said, the question is not whether the consequences ought to have been foreseen, it is whether the defendant caused the pollution. And foreseeability is not the criterion for deciding whether a person caused something or not. People often cause things which they could not have foreseen. Now, some people may retort that if we take this approach, it's all very lucky for A. If she were to escape liability for causing death by dangerous driving, if the lorry driver turned out to be asleep, rather than, as one might have expected, him just deliberately going over to the hard shoulder and not happening to see A because of her unlit car. But even if that would be lucky for A, so be it. Causation does permit of luck, just as the fraudsters of old would get away with it if their victims happened to be too dazzled by their style and not concentrating upon the substance of their fraudulent statements. Similarly, it seems to me A gets away with it if her dangerous behaviour in parking where she was unlit didn't actually affect how the lorry driver crashed into her. She was guilty of dangerous driving still. That offence applies precisely where a person does things which creates risks of accidents, but she still didn't cause that accident, in my view. So those are my two messages. Look out for acts and omissions and the important difference between the two of them when doing factual causation. And if you are before judges in the Court of Appeal in cases where they try to talk about whether links in a causal chain were foreseeable, do your best to steer them away, please. And that's all I was going to tell you. How have I done for time, Findlay?
Almost perfect.
Well, I've never told
30 seconds.
Perfect, so
30
I'll
seconds
leave it
over.
there. And thank you very much for listening.
Thank you very much, Jonathan. Okay, Jane.
I remembered to turn myself on. I'm going to go back to the top of the agenda. I first want to make a large disclaimer. I know next to nothing about criminal law. So I was a little reluctant to join the panel, but Findlay persuaded me that I should freely and voluntarily offer up my reactions, even though they were so uninformed. And he gave me some cases to think about involving this area of causation and responsibility for consequences. So everything I say, please be compassionate to someone who knows very little about criminal law. But to a private lawyer like me, it looks like criminal lawyers are in a bit of a mess when it comes to using causal terminology to frame your two quite distinct questions. As we all know, one of these questions is whether the defendant's conduct in violation of a legal norm was necessary for the outcome or otherwise contributed to the production of that outcome. Importantly, as we know, this inquiry is a factual question. It's a question on which reasonable minds couldn't differ if they agreed on all the relevant facts. And that's why, if the defendant's conduct was related to the outcome in this way, it's helpfully described as a factual causative. So I've always argued that clarity is vastly improved, and in your case, not least for members of the jury, if it is only this inquiry that is described as the causal question. As we all know, the other inquiry is the normative question, whether a consequence of the defendant's violation is judged to be within the appropriate scope of the defendant's legal responsibility. Obviously, the second question is a normative one on which reasonable minds could well differ, even if all the relevant facts were agreed. 70 years ago, in their book Causation in the Law, Hart and Honore promoted an unfortunate amalgamation of these two distinct issues, one factual and one normative. In their analysis, the answer to the second, the normative question, could be framed as whether or not the, quote, prescribed causal connection, unquote, was present. This amalgamation is unhelpful anywhere in the law because it obfuscates the normative character of the second inquiry. Using the word causal makes it sound more mechanically factual than it is. Now, this confusion can clearly be seen in Hughes, where the Supreme Court stated, quote, "It is trite law that the meaning of causation is heavily context specific. It's not always safe to suppose that there is a settled or stable concept of causation, which can be implied in every case," unquote. But the meaning of factual causation is not in the least bit context specific. What is context specific is the responsibility for consequences question. And this is because the legal concerns that bear upon the question of the appropriate scope of responsibility vary according to the purpose of the legal rule. For example, the scope of responsibility for consequences of a violation is drawn more widely for intentional torts, such as deceit, than it is for torts that don't require intention, such as negligence. I suspect the same is true for the criminal law, that the scope of responsibility for consequences for grave offences is different to that for less grave offences. And I'd be interested to know if anyone can give me some examples of this. Private lawyers are getting much better at framing this second, the normative question, not in causal language, but in explicit terms of the responsibility principles relevant to the cause of action. As we all know, criminal lawyers still use causal language for the factual question and for the separate normative question about legal responsibility. I've heard this defended by an assertion that we can have faith in the jury to be able to handle instructions presented in this compound way that Hart and Honore promoted. But having read the criminal cases Findlay suggested we read, I think that using causal language to frame the responsibility for consequences question in criminal law is not satisfactory at all. In many cases, the word causation is used to refer to the factual question and to the responsibility for consequences question in the same case, the same word used for two different things in the same case. This frustrates the usual common law method for identifying what a term means in the law. We discover what words such as duty, breach, trust, consideration mean in the law by seeing the context in which judges use them in the cases. This technique can only work if judges use a term consistently. In my view, bench, bar, and juries would be mightily assisted if the second, the normative question, were framed not in causal language at all, but in explicit terms of the responsibility principles relevant to the offence. One, but only one of which concerns the intervention of a free, voluntary, and informed act or decision by another party. So turning now to some points about the meat of the law. I'm going to do this in 3 steps: factual causation, proof of factual causation, and responsibility for consequences. On factual causation, let me make just 2 quick comments. 1, when the law is dealing with conduct, factual causation is not about raw acts, but about the legally relevant aspect of the conduct. In Hughes, one interpretation of the purpose of the statute supports the conclusion that something more than driving was the aspect of concern in the creation of the offence. It was that relevant aspect of the driving that had to be a factual cause of the injury. The only appropriate candidate for that relevant aspect that Parliament was interested in was being uninsured. This made being insured the appropriate counterfactual for the factual causation inquiry. Since being insured would have made no difference, being uninsured didn't qualify as a factual cause. I think, by the way, this is also relevant to the case Jonathan was just talking about, case of A. The relevant aspect of the conduct in that case was not having the car's lights on. Yet that made no difference to the outcome. So it doesn't seem to me that the relevant aspect of the conduct was a factual cause of the consequences. The second comment I have is to emphasize that the but for, the sine qua non test, is not an exhaustive test of factual causation. A factor might be a factual cause of an outcome, even though the factor was not necessary for the outcome or sufficient for the outcome. The UK Supreme Court has confirmed this in the Financial Conduct Authority and Arch Insurance last year. The relevant paragraphs are 182 to 185. For those of you who are familiar with criminal cases in the US Supreme Court, you'll realize that this recognition by our Supreme Court illuminates situations such as those in the 2 criminal cases before the US Supreme Court in 2014 called Parolini, involving multiple downloaders of child pornography, and Burrage, involving multiple drug suppliers. But since none of Findlay's cases involve unnecessary causes, I'll pass on to proof of factual cause. I'm going to touch here on the case, again, Jonathan mentioned, Broughton. This hinged on the level of proof required in the counterfactual and omission cases. And to me, it seems uncontroversial. Expert evidence was all the jury had to go on, and it wasn't capable of establishing factual causation to the criminal standard of being sure. I might just say here in response to Jonathan, I actually think counterfactuals are also involved in cases where the violation of the norm involved an act. But I'll leave that to one side, maybe we can talk about that in Q&A. So moving on to responsibility for consequences. If you use causal language for the normative question, you end up with statements such as that in Hughes, that causation is, quote, heavily context specific, and other phrases such as certain phenomena break the chain of causation. But as I said, that framing is confusing, incoherent, and might dangerously suggest that the concept of factual cause varies across law according to the purpose of the legal rule, which it doesn't. In intervention cases, what's broken between the defendant's violation of a legal norm and the consequence is the nexus of legal responsibility. Nothing to do with the facts of what happened, nothing to do with what was the factual cause of what. So I think we need to avoid framing this as breaking the chain of causation. By spelling out the responsibility principles in play beneath that general phrase of breaking the chain of causation, we can spell out what the parties need to address, understand how it can be that the law of responsibility for consequences may vary and be heavily context specific. And we can give juries concrete guidance that at the moment jury instructions couched in causal terminology conspicuously fail to do, at least in my opinion. Let's take the relevance of interventions again. Hart and Honoré notoriously fail to appreciate, or at least clearly explain, that there is a massive difference between how the responsibilities principles of the criminal law respond to natural or human interventions, and how private law responds to such interventions. For example, in private law, there is no responsibility principle that says that the intervention of an abnormal event such as lightning or the free, voluntary and informed act or decision of another party relieves the defendant of legal responsibility. Quite the opposite. Just think Dorset Yacht. Defendants are often liable in tort law for consequences flowing from such interventions, including lightning and the suicide of the victim and so on. In contrast, it is obvious that in criminal law, there is a special principle relevant to responsibility for consequences, of which the defendant's conduct was a factual cause, namely that legal responsibility will not attach to the defendant if there intervened what courts call a free, voluntary and informed act or decision by another party. Glanville Williams called this the Autonomy Doctrine, but both he and others, such as Lord Bingham and Kennedy No. 2, often couched in causal terms. It becomes crucial to know what principles of responsibility for consequences courts have identified lying beneath notions of free, voluntary, and informed, not least so that juries can be instructed on the detail of these criminal responsibility factors. Let me suggest how this might help. At present, it's said that the offence of murder is committed if, unlawfully and with intent to kill, a person does an act which causes the death of another. The Crown has to make sure that the defendant's act was a cause of death. It need not be the sole or principal cause, as long as it was a substantial cause, which meant a more than minimal cause. Now, causal terminology here masks the key principles of responsibility for consequences that are driving the judgments in the cases. For example, the Crown has to make the jury sure that the circumstances were such that the victim did not make what courts label a fully free, voluntary and informed decision to risk death. Yet jury instructions, such as those suggested at the end of Wallace, don't even mention these responsibility features of fully free, voluntary and informed decision. Instead, their reliance on causal incantations alone seem pretty obfuscatory and unhelpful to me. Why aren't juries instructed directly about the responsibility principles? Certainly, we can deduce from the cases responsibility principles, which juries can hear and which may form the basis for the jury being sure that D should be criminally responsible for murder. Let me give two examples from the list Findlay gave us. From Thiel, we could get the principle that if the defendant actively concealed his hostile intention from the victim, who as a result was uninformed about it, this may change the nature of the act that the other person thought he was embarking on and render it more dangerous than the person perceived. And the degree to which this is the case may persuade the jury that the defendant should be criminally responsible for the consequence. Another responsibility principle can be deduced from Wallace, where the victim calmly decided on a lethal course of action because the injuries from the defendant's unlawful act plunged him into a terrible situation. The severity of that situation may persuade the jury that D, the defendant, should be criminally responsible for the consequence. Notice I haven't used the words free or voluntary to capture the substance of Wallace. This is because I think the mantra of free, voluntary, and informed sometimes it gets in the way of capturing what is in substance the factor of legal relevance. In Wallace, it was the severity of the situation the defendant was plunged into. So I'm going to finish up now because I know Findlay's keeping time. But I just want to say that I hope I've not made too many blunders in my take on this area of the law. I'm sure I have, and so I thank you for your forbearance.